Okay, I need to tell you, it looks like we may have the decisions on higher ed. Hold on a second here and let me look. It is fast and furious this morning, but there is the concern for people who were challenging the student loan program is that they would get hit with standing and not actually get to the merits of the case.
Right.
So that has been a big issue. We saw this with the immigration case last week. Texas and Louisiana tried to bring a case about immigration policy, and we're told they didn't have standing. And people are like, if these two states don't have standing, who does have standing? Okay, so it looks like Harvard and UNC's admissions programs, where they used race as a factor in the holistic determination of letting people in. The first read on this says that, let's see here, admissions programs violate the Equal Protection Clause of the 14th Amendment. Got to read the whole opinion to see here, but that's at least the first impression that our producer is getting from this. So that would be enormous. Now, we've been watching this case to see, would they swing for the fences? Would this be very narrow? Generally, the Roberts Court does as narrowly tailored as possible when they are trying to make a decision about something. And this issue of, oh, look, here we have, Keegan has run these out to us. Keegan, thank you very much. Okay, so let's look here and see. This is
Shannon,
the Harvard
we could
and UNC
give you
case.
a moment and to read through that and go to Jonathan Turley if you'll allow us to give you just a moment to breathe.
Yeah, this is by the Chief Justice, as we expect. He's handled most of the affirmative action cases, and Professor Turley will know that quite well.
Okay, we'll be right back to you. Jonathan Turley, Professor, good to see you. So this is one of the big cases we've been waiting for on affirmative action, and it appears that it wouldn't be a surprise if this is thrown out as on a constitutional matter.
That's right. It appears that it has gone the way many of us expected, particularly when we saw who the author is. Chief Justice Roberts has said for years that the best way to stop discrimination is to stop discriminating. And he has opposed racial classifications in college admissions. This is the culmination of decades of cases that were very much muddled and divided. It started in the 1970s with Bakke, when the Supreme Court technically said, we are saying you cannot do affirmative action in admissions. But it allowed for race to be considered as one of the criteria for admissions. And they often, ironically, cited Harvard to say that Harvard had this holistic approach to admissions and that, you can do something like that. Well, the universities used that and they sort of drove a truck through it. I mean, that was not that was an ample space, and they started to argue more that they were adding diversity to their class, which is not a bad faith argument. Most academics want to see diversity in class. Most universities do. But the courts got more and more uneasy, particularly the Supreme Court, and they felt that this was an end run. And justices really were divided. You have a series of 5-4 decisions, including one decision where Justice O'Connor said, we're going to allow you to use race for admissions, but we don't think you're going to be able to do this beyond a certain date. Well, this is almost that date. Roberts and others reminded these schools that time is up, that even O'Connor, that signed off on those close decisions, said this was not going to be something they'd be comfortable with doing in the long term.
And Professor, if you'll just hold your thought there, let's go back to Shannon Bream. And she's now had a chance to read through this. I understand, Shannon, that there might have been 3 dissents?
Yes, we've got a mixture of opinions here. This is one of those ones where we've got a majority opinion, we've got concurrences, we've got dissents. Let me read you a little bit from the majority opinion, which of course will control here, written by the Chief Justice. He says both Harvard and UNC, so again, you've got a public and a private school, but both take federal money. Both programs lack sufficiently focused and measurable objectives warranting the use of race anywhere in their admissions process. That they're unavoidably employing race in a negative manner involving racial stereotyping. That's what these Asian American students had alleged, and lack meaningful endpoints. We've never permitted admissions programs to work in that way, and we will not do so today. They do go on to say, though, at the same time, as all parties agree, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life through discrimination, inspiration, or otherwise. So these essays that students will write, possible students, the applicants will write, talking about what their experience has been, the court says, we're not going to rule that out. Of course, people can have discussions about what what led them to this point in their life, whatever that is. They go on to say a benefit to a student who overcame racial discrimination, for example, must be tied to that student's courage and determination, or a benefit to a student whose heritage or culture motivated him or her to assume leadership positions, those kinds of things. So basically they say, the universities have too long done the opposite. They've used a race in a way that's actually hurt other races. They've concluded wrongly that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned, but only the color of their skin, and our constitutional history does not tolerate that choice. Let me read you just a little bit from the dissent. This one is written by Justice Sotomayor. She says, the court is standing in the way and rolling back decades of precedent and momentous progress. It holds race can no longer be used in a limited way in college admissions to achieve critical benefits. In holding so, the court cements a superficial role of color blindness as a constitutional principle in an endemically segregated society where race has always mattered and continues to matter. So a clear split between the two sides in this case. But again, race as a factor for admissions, not going to be allowed in higher ed.
Shannon Bream, thank you so much for that quick work. And I know there could be additional hearings.
I'm Steve Ducey.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.